Very good afternoon, everyone. So, in the today's session, we are going to revise the chapter Prospectus and Allotment of Securities. Compulsory a 6 marks to 8 marks is coming from this chapter as well. 3 chapters: Management Administration, also called as General Meetings, Share Capital, and next one is the concept of prospectus. These 3 chapters are accounting for 25 marks in exam. In that, as you said, management administration being general meetings is over. Share capital we completed in the last session. So we are left out with another one area called as prospectus. So once this is completed, the main area of all the important concepts will be completed. All the remaining concepts are just a small areas of 3 marks, 4 marks, and some are optional chapters. So with regard to the chapter prospectus and allotment of securities, there are sections starting from section number 23 ending with section number 42. In between, 1 or 2 sections are not applicable for exam. When we come through that, I will explain. So with regard to the applicable part of your syllabus, prospectus and allotment of securities is the area we are going to complete in the today's session. Okay, please open whatever the book you are following. Name of the chapter: Prospectus and Allotment of Securities. Name of the chapter: Prospectus and Allotment of Securities. Before we start with the chapter Prospectus and Allotment of Securities, let me make certain things clear. There are 6 kinds of forms that are applicable for your exam. PAS1 covered in section 27, advertisement related details. PAS2 section 31 will cover this, talking about information memorandum format. PAS3 section 39 and section 42, return of allotment, which will be filed with ROC. Normally 30 days, private placement 15 days, 39 ki 30 days, 42 ki 15 days. PAS4 section number 42, private placement. This is the prospectus type. There is an application form. Format for application form for private placement is PAS4. PAS5 again section 42, register of private placement, that's called as a record. PAS6 section number 29, okay, which will be talking about every half year filing has to be done by unlisted public company. That will be dealt here. So these are the 6 forms that are made applicable for your syllabus. First of all, everyone, did you see all the 6 forms on the screen there? Everyone. So there are 6 forms totally. Observe all the 6. And moreover, second question, do you have all of you have these charts with you? In the Telegram channel, these are made available. You didn't find this? Sir, no worry. If it is not there, immediately after the class, I will upload. Have it such that the summary revision will be completed through this particular charts. Clear? Did you find the charts for general meetings, share capital, other chapters? Okay, I think then I might have missed the chapter prospectus. Then definitely I will get it done. So prospectus and allotment of securities, this particular charts material will be more than enough for the examination. Either read the study material as already said, okay, or if you want little time to complete everything, prepare from the charts. Charts also will cover the same content. Shall we begin? Let us start with the concept. See here. This chapter starts with section number 23, end with section number 42. 23 will be talking about the concept of 23, public offer and private placement. 42 will be talking about the private placement offer. From there till then, there are so many aspects which we need to cover. So one by one, let us try to complete them. First one, private offer or public offer and a private placement. First one, whenever we say a private offer, public company and a private company, both the companies can make a private offer, but public offer can be made only by public companies. To put it other way, private companies cannot go for public offer, but public company can go for private offer. Yeah, private offer can be made either by public or by private company, but but the public offer can be made only by public companies, but not by private limited companies. Point number one, observation one from section number 23. Let's see what is there in section 23. Public company to issue the securities. Public company may issue the securities through the prospectus in the form of public offer. It can also make a private offer. So, public company can make public offer, public company can make private placement under section 42. Along with that, share capital chapter law already we read, rights issue, bonus issue. These also can be made by public company. Rights issue, bonus issue. As per this act, if it is a listed company, SEBI guidelines also will apply. So start from the beginning. Section number 23. Concept is public offer and private placement. Okay. First, public company can go for public offer or private placement under section 42. These two are dealt by chapter 3 of Companies Act, prospectus. This is dealt by chapter 4, share capital. Already rights issue, bonus issue concept we have completed. Okay. This is for the public company. Question arises, sir, my company is not a public company. My company is a private company. Then what can I do? You can go for private placement. You can go for rights offer. You can go for bonus offer. Answer over. Private company may issue securities by private placement under section 42 or rights issue and bonus issue under chapter number 4, share capital. Yeah. So whenever I say public offer includes initial public offer, further public offer, even offer for sale. We will read what is offer for sale. Next. Main concepts only I am covering. Next. Some important definitions. What is the definition of the term prospectus? Prospectus is a document which is described or issued as a prospectus. Means, take a document, on the cover page of the document, if you write prospectus, you describe it as a prospectus or not, automatically it will be deemed as a prospectus. I repeat one more time. Take a rough paper, write down that there prospectus of TCS, and if directors and chairmen sign on that, that will be prospectus. Sir, how come a nonsense paper can become a prospectus? That is different issue. The moment you describe something as a prospectus, it will take the form of a prospectus. But on a rough paper, if you open prospectus, contents will not be there. Directors will be kept in jail. Therefore, when you are writing on some document as a prospectus, keep all your 5 senses with you and then write down. Or else, ruthlessly punishments are involved under section number 447 for giving wrong information in prospectus. So therefore, prospectus is a public document. Means reading the document, believing that the facts mentioned in the prospectus are true, people will purchase the shares in your company. Just like that, don't take the advantage of people and loot their money. So therefore, logic is very simple. What is a prospectus? Any document described as a prospectus is a prospectus. Number one. And it includes. Whenever I use the word includes, it means for example, we are giving some examples only. Hey, are you with me? So whenever we say includes means we are telling for example, red herring prospectus under 32, shelf prospectus under section 31, or any notice, circular, advertisement, or any document. So any kind of document, name it in different way. You call it notice, you call it circular, you call it advertisement, you call it a document, you put any name you want. What is your motive? Motive is to invite the offers. Motive is to invite the offers. From whom? Public. For what? Subscription. Subscription of what? Securities. Securities of whom? Body corporate. That's it. It will become a prospectus. So what is the definition of a prospectus? Prospectus means any document described as a prospectus. Over. And it includes red herring prospectus under 32, shelf under section number 31, any notice, any circular, any advertisement, any document, listening, which is inviting the offers from the public to subscribe for the securities of a body corporate, it is automatically becoming a prospectus. Everybody answer understood the point clearly? Next, I use the word security. I did not use the word share. This chapter is applicable for securities, not for share. So not for share means shares is not applicable. No, no. In security, one of the thing is share. Share is not, share is a security, but every security may not be a share. Yeah. Debenture is a security. Bonds, security. Preference share, security. Commercial paper, security. Listening? Deposits, a security. But those are not shares. So therefore, security is defined under section 2 clause H of CRAT. Okay. Shares, bonds, debentures, derivatives, collective investment scheme, mutual funds, government securities, etc. Okay. So therefore, the point is security word is a wider definition than that of the definition of a term share. Share includes only an equity instrument. Security includes equity, derivatives, debentures, everything will be included into it. Everybody answer first part section 23 understood or not? So with this, we have completed section number 23 and some definitions. Let's sum up everything. Once I complete a concept, I will sum up everything and go to the next one. 23 talks about eligibility of public and private company. Public company can go for public offer, private placement, rights offer, bonus offer. Private company can go only for private. Therefore, only three things it can do: private placement, rights offer, bonus offer. Answer over. This is section 23. Next, definition of a prospectus. Prospectus means any document described as a prospectus and includes red herring 31, 32, shelf 31, any notice, circular, advertisement or any document inviting the offers from the public for the subscription of securities of a body corporate will be termed as a prospectus. Yeah. Security does not mean just a share. Security la one of the entry is a share. Security includes shares, debentures, stock, debenture stock, collective investment scheme, units of mutual fund. So many things are included into it. Okay. I'm putting the chart on full screen basis. 1 minute time. Revise everything fast. We'll go to the next one. completed. Next. Next one. 24 and 25. Open whatever the material you are following. '24 and 25. Whether you are following the Bare Act or study material, open that. Shall we continue? See here. 24. So this is a summary notes. Therefore, don't come across each and every point and compare. Okay, from the absolutely from the exam's point of view, what are all the core important points I kept here? Here. In exam, if a question comes, what we need to write? Those contents only I kept here. So don't compare on one-to-one basis. Okay, this is a summary. So let us see. Power of SEBI. Power of SEBI. To do what? To regulate the issue and transfer of securities. There are two problems in securities market. Number one, issue of securities, or public issue or private issue, anything. Okay. Second one is a transfer of securities. Means how to transfer the shares from one person to another person. These two things in India are governed by SEBI. See here. SEBI is empowered to regulate issue of securities, transfer of securities, or non-payment of dividend by a, clearly they only said, by a listed company. If you are a listed company, your issue of share, first one. Second one, your, listening everyone, your issue of shares, your transfer of shares, your non-payment of dividend. Issue of shares, transfer of shares, non-payment of dividend. Okay, three things. ITD, issue of shares, transfer of shares, non-payment of dividend. These three things are dealt by SEBI. In case of which company? Listed company or companies which are intended to get listed. What you may intended to get listed? Not a listed company, but applied to SEBI for getting listed. So in that pending period, it is there for both kinds of company: issue of security, transfer of security, non-payment of dividend. These three matters are dealt by SEBI only, not by MCA, not by Companies Act. Everyone understood the concept clearly? That's it. That is what said in section number 24. Let's read one more time. SEBI is empowered to regulate issue and transfer of securities or non-payment of dividend by whom? By listed company or companies which are intended to get listed on recognized stock exchange. Everyone understood the concept clearly? Done. With this, we have completed section number 24. Next one. Section number 25. There are two connecting sections. One is 25, another one is 28. One is 25, another one is 28. 25 and 28. Shall we begin? Two connected sections are there. One is 25, another one is 28. Okay, let us begin. Okay. See here first. Look here. I will explain both the sections together. 25, 28. Two sections are there. Both are two connected sections in this chapter. Let us cover both together, revise them. Important areas I will cover in this. What is required for the exams? See here. Both are discussing about one common aspect. Called as deemed prospectus. Called as deemed prospectus. Means when I use the word deemed, it means we should feel that it is a prospectus. Means what? Really, it's not a prospectus. Okay, we have to feel that it is a prospectus. And a reality, it's not a prospectus. If a reality it is a prospectus, there is no need to deem. Clear? The need for a deeming fiction arises only when the reality is missing. Okay, and in reality, if you see, it's not a prospectus. Yeah, but when you go into the deep into the analysis, we will feel that our conditions on prospectus should also apply to them. Okay, so understand the concept clearly. 25, 28. Listen, first I will explain section 28 summary. What is 28? See, companies can go for public offer in two ways. One, direct public offer. Second one, offer for sale. Repeat, everyone. Don't sit like that. Everyone answer. What are the two types of public offer? Direct public offer. Second one is offer for sale. Sir, what is the difference? Listen, I will explain. There is a company called as X Limited. X Limited is in need of funds. It will take money from public. This concept is called as direct public offer. It will issue shares, take money from the public. Up to here, everyone understood? There is a second type also. X Limited. In this X Limited, there are 10 lakh shareholders holding 10 crore shares. In this 10 crore shares, 10 shareholders are holding 3 crore shares. Means substantial 30% of the total wealth of the company is in the hands of how many? 10 people. Okay, 10 shareholders hands, 30% of the capital of the company is concentrated. Okay, money is blocked in their hands. Clear? You should understand this in two angles. Substantial 30% control of the company is in the hands of 10 people. In that way, you can interpret. From their point of view, if you see the same cinema, how it look like? For example, company has 10 crore shares. In that 3 crore shares are held by these 10 people only. Each share is 100 rupee. Okay, means how much money? 300 crore money. So a public person, normal person like you and me, how do we will see the same cinema? 100% capital, 30% is held just by 10 people. Like that we will see the cinema. But cinema should always not to be seen from the audience point of view. Also from the storyteller point of view, you should see. Therefore, from the other person point of view, for example, if I am the promoter holding those in the 10 shareholders, I am one among. How I will feel? Ayyo, my 30 crores amount is blocked in this company shares. Like that also I will feel. Hey, listening. My money is blocked in this particular company. So like that also you will feel. You are feeling from the public point of public will feel 30% is held by 10 people. No, see from my side. Okay, how the 10 shareholders will feel? Ayyo, huge amount is blocked in this company. I want liquidity. Like that I will also feel. Correct. From their point of view, when you see the cinema, section 28 will start. Section 28 says that, okay, whenever members of the company feel that their money is blocked in the company shares and the liquidity crisis came to them, they will try to sell their shares to the public. They will try to sell their shares to the public. When existing members of the company are diluting their capital holding, then section number 28 will get attracted. That's called as offer for sale. Understood the point or not, everyone? Today's generation, that is extremely popular concept. What is the popular concept in the today's world? Offer for sale. Do you know what they will do? Start a company. Expand the company. Make it popular. Sell the shares to public. Answer over. Sir, what about company? Let the company live or die. I don't care. Members are making profit out of this deal. Same happened with LIC. Same happened with Zomato. All these super duper hit public offers are offer for sale. Example, I will tell you. LIC bank balance and amount held in the bank by LIC deposits is running to 8.5 lakh crores. Not 1 crore, 2 crore. 8.5 lakh crores is the bank balance of LIC. Are you understanding the point or not? Simply to tell, LIC bank balance is, if it is liquidated completely, India can forget about budget for next coming 10 years. That much bank balance LIC is having. Clear? And every year 1 lakh crores it can give for the Indian budget. That much amounts are there with LIC in the bank. Forget about other investments. Okay, that much money is there. Do you know what happened? 2021 year, LIC went for a IPO, initial public offer. Do you know how much money they went? 21,000 crore. Now doubt will come. In your bank balance, 8 lakh crores are there. Why you need 21,000 crores? Did you understand my point or not? Who will give loan like that? For example, I went to a bank. I said, bank, please give me loan. They said, okay, give your balance sheet. I gave my balance sheet. Cash. Listening, everyone? I went to a bank. I asked, bank, please give me 10 lakhs loan. Bank said, okay, I will give you your balance sheet. I gave my balance sheet. Balance sheet, the bank balance is 1 crore. Okay. Immediately bank will throw that papers on my face and tell, are you idiot? Your bank balance is 1 crore. Why you are asking bank to give another 10 lakh loan? We will not give. Do you understand my point or not? That's the reason why in financial management, people always say debt equity ratio must be 2:1. Already you are having 1 rupee, means I will give you 2 rupee. If you have 2 rupee, why I will give you 2 rupees again? Are you understanding the point or not? You should always have lesser amount than the debt. That is the ideal way of doing the business. Already you are having 1 crore rupee. Asking 10 lakh rupee loan means, are you a fool or what? You can use your own capital. Na? So therefore, LIC same question will get arise. Your bank is having 8.5 lakh crores bank balance. You came for 21,000 rupees, 21,000 crore rupee cash. Already you are having 8 lakh crores. Are you first connecting yourself to the concept? Means what could have happened with LIC? LIC don't want money. LIC already have lot of money with it. LIC don't want it to go for public offer. In LIC, Government of India is the major stakeholder. Government of India is the major member. Government invested 76% capital in LIC. What Government of India has done in the year 2021? BJP government at that time in 2021 took a decision. What decision? Government of India want money. So 3.2% of government shareholding came to 21,000 crores. Government is already holding 76%. 76%, 3% they sold to public. Yeah. And 73% government is holding now. 3% value came to 21,000 crores. And you imagine how big LIC is. Hey, listening everyone? 3% equal to 21,000 crores means how much 76% will be equal to? 76% if it equals to that much amount, how much is 100% equal to? Such a big company LIC is. LIC want money. LIC don't want money. Members of LIC felt that their money is blocked in LIC. They decided to sell the shares to public. Hopefully you are listening. Okay. Now, after entire discussion is completed, you will give me an answer with common sense, if any. Tell me. Point number one. In LIC, who is giving an offer? LIC is giving offer to public. No. Members of LIC is selling their shares to the public. But members of LIC, if they sell shares to the public, what will happen automatically? It's a private deal between members and another outsider. Therefore, lawmaker thought that it is undesirable, allowing the members to sell outside. Therefore, listen carefully what they have done. Members will first tell the board of directors. Board of directors, our batch is holding 30% of the total share capital. We don't wanted to continue in this company. We wanted to sell 30% in one go to public. The moment 10 people batch are selling 1 crore shares, there are around 20-30,000 people who will buy this. Suddenly the company shares are now going into the hands of public. I will give you one super example. Previously, 21,000 crores is also held by whom? Government. Now who is holding? Kaushik Mukesh is holding. Seriously, not 21,000 crores. I have shareholding of around 20 lakhs or 25 lakhs in LIC. And in this 21,000 crores, Kaushik Mukesh is also a owner now. Ray, did you get the point or not? Like me, 65 lakh people bought the shares of LIC at that time. Clear? People will tell, there is one saying in Telugu. I will translate it in your language to make you understand. Jungle will be there. In the jungle, lion will be there. Okay. Lion will be sitting idle for 10 days, almost 1 week to 10 days. One day, one solid hunt it will do. Okay. That's it. Next 10 days, it will not hunt. Happily, it will eat and it will sleep. After eating everything, the flesh, everything, remains will be there, na? Bones, other particles, flesh, everything in the animal. Yeah. Vultures, hyenas, fox, wolf, another 100 wild animals will eat that. LIC is like a lion here. Simply to tell, central government is like a lion. Central government ki 3% share if it leaves, na, people like us will feed on the 21,000 crores. Are you understanding or not? So the point what I wanted to emphasize here is, it may be 3% to the government, but it's not 3% to me, na. How Mukesh can spend 21,000 crores? If that 21,000 crores, if I have, why I will shout in the afternoon time? Happily I will eat and sleep. Are you understanding or not? So therefore, my point is, it may be very small for the government, but it is very big for public. Yeah. Person with a little amount of 5-6 crores wealth like me, lakhs wealth like people, how can they afford for 25,000 crores to 21,000 crores? Not possible. Therefore, listen carefully what I am trying to tell. Members will be there. Batch of members, big holders they call. Okay. These people will go to board. They will tell board of directors, we don't want it to continue. Okay. We wanted to sell our shares, but not to you, but to the public. Then board of directors will tell, hey, ours is a private company. If you sell the shares to public, it will become public company. Members will tell, that's what we also want. We are not selling 100% of our shareholding. Government said, 76% we are not selling. 3% only we are selling. 73% still with us only. But this 3% may be 3% for me. I'm the lion, na? But once I sell that 3%, hundreds of other animals will feed on that. Yeah. So therefore, LIC did not want money. LIC did not go to public offer directly. Members of LIC convinced the board of directors of LIC to sell their shares to the public, making LIC a listed public company in the year 2021. Till then, LIC is a unlisted public company. Well, did you understand all this discussion, whatever I said now? Everyone. So, logically speaking, okay, logically speaking, LIC is an unlisted public company, even today. But it is getting the brand of that listed company not because of LIC, because of these members who sold the shares. This only central government, Narendra Modi, time to time used to say, we wanted to privatize LIC, they are privatizing LIC. Means previously shareholding of LIC is in the hands of public, now it is in the hands of private people like you and me. Privatization means not putting that in the hands of Ambani. Privatization means putting in the hands of private people. Are you understanding the point or not? Hopefully everyone got the point clearly. Okay. So the logic what I wanted to tell, why I'm spending this much time, 25, 28 looks alike, not same, looks alike, similar, identical, not absolutely same. So 25 section, tell me, who will sell? Members. Convince whom? Board of directors. To sell their shares to whom? Public. But they cannot sell directly to public. But they cannot sell directly to public. What they have to do? They have to go through the board of directors. Clear? Therefore, what will happen? See there. See the screen. See the screen here. Members. Company. Public. Okay. Members will convince the company board of directors. Company will offer the shares for sale. That's why the name came as offer for sale. Start again. Company will give offer. For what? For sale. Sale of what? Shares. To whom? Public. Everyone repeat, what is this? No, it's not offer for sale. This will be deemed as a prospectus. This offer for sale will be deemed as a prospectus. Simply to tell, do you know what does it mean? LIC did not go for public offer. LIC gave only offer for sale. LIC gave only offer for sale. But that offer for sale document will be deemed as a prospectus. If it is deemed as a prospectus, what will happen? All the rights, all the liabilities, all the obligations, all the privileges attached to prospectus will also apply to the deemed prospectus. Simply to tell, prospectus has what right? Right to tell about company. What liability? If something is a nonsense in the prospectus, directors will be kept in jail. Whatever is applicable to a normal prospectus equally applies also to the deemed prospectus. Understood, everyone? See, first 28. See the screen. Where certain members, when I say imagine the story in the background, visualization should come in mind. Where certain members propose in consultation with the board of directors. So members consulted the board of directors. In my diagram, did you visualize the thing? What is the purpose? Why they are coming to the board? To offer whole or part of their holding to public. Tell me, LIC is whole or part? Central government sold whole of their holding, part of their holding. Part of their holding. How much part they sold? 3.2% only. Okay. Next, the members shall collectively authorize the company to take necessary action for the offer for sale and then reimburse the company for the expenses incurred. That's it. Everyone understood the main point clearly, yeah? Okay. Now, listen. Not yet completed. Listen carefully also to this point. So, see here. Following provision of this chapter shall not be applicable in case of OFS. Okay, one by one. The provisions relating to minimum subscription, provision relating to minimum application value, provisions requiring statement to be made by board of directors in respect of utilization of money, any other provision or information which cannot be complied or gathered by the offeror with the detailed justifications, and prospectus to disclose the name of the persons bearing cost of making OFS and reasons. Sir, what is all this, sir? I didn't understand. First of all, everyone tell me, did you understand these 4 points on the screen first? Tell me, who are approaching? Members. Approaching whom? Directors. To do what? To offer their holding to the public. Members will collectively authorize company. In our example, LIC. And whatever LIC has done for the members has to reimburse the expenses to the company. Over. Read this concept now. Start. Document by which such OFS is made to public shall be deemed to be a prospectus issued by the company, and all provisions relating to the content and misstatement shall apply. That point also I said. Sir, those understood, sir. But these things I did not understand. Common sense again. Okay. What is that common sense point? See, do you know whenever public offer is made, application money, allotment money, first call, second call, final call, 5 parts will be there. Correct or not? Offer for sale, all those things will not be there. Offer for sale, one stretch, like everything will come. Okay. Minimum subscription, application money collection, all this nonsense will not be there. Shall I tell you one example from my side? LIC, when I purchased 902 rupees, I purchased each share. How much? 902 rupees I purchase each share of LIC. Okay. Sir, application money how much? Allotment how much? First call, those concepts are not there. One day, December 23rd or 24th, 2021 year. Immediately bank account lo total 20 lakhs or 18 lakhs deducted. That's it. Application money, allotment, first call, second call, all these things will not be there. Offer for sale, minimum subscription concept will not be there. Minimum application money concept will not be there. Clear? How board is going to utilize money in phases, means application money, how they are using, allotment money, how they are using, and the concepts will not be there. The reason is very clear. Money is received not by LIC. Money is received by the members of LIC. Hey, are you here, everyone? If public raise the if company raise the money from public, company is responsible to tell how it is going to utilize the money. Offer for sale, company is not receiving the money. Who is receiving the money? Members are receiving the money. Therefore, what utilization will be there? No utilization. Understood the point or not, everyone? And last point, prospectus to disclose name of the persons or entity bearing the cost of making the OFS and reasons. Means, for example, 100 people group, they formed a group of members, they wanted to sell. Okay. They will not sell directly to public. Company will issue prospectus, everything. Company will incur a lot of cost. Okay, who will reimburse? One or two people in that 100 will first reimburse. Who are those people? Clearly make the disclosure in the prospectus. That's what he wanted to tell. Okay, this is all about the concept of section number 28, offer for sale. Okay, I'm putting it before you on a full screen. Read it, complete it fast. Can you go to the next one? Let's move on to the next section. Section number 25. I'm covering the connected sections. See, section 25 also, I will tell you the logic and the section. See here. See here once. There is a company. It is a issue house. And public. Okay. Listen carefully. Company, issue house, and public. Okay. See here. Here concept will slightly change. This issue house can be either a company or LLP or a firm. Anyone it can be. Listen carefully. This is like revision. Each and every minute detail I will cover, but only once. If you don't listen, that's not my mistake. See here. What will happen in this case? Let's see. There is a company. This company wanted to go to public by issuing the shares, but it will be unsuccessful because this company is not so popular in the public. Your company may be very good company, but publicity is the main striking feature in the today's world. Okay, how good you are in your performance is secondary. First thing that is required is publicity, promotion. How you promote yourself, the product into the market plays a crucial role. If you are not popular, at least you take the help of a person who is already popular, collaborate with him and you go. Clear or not? That's the magic of the entire Instagram algorithm. Na? The entire Instagram algorithm works on the concept of collaboration. Means if you are not popular, now do one thing. If any person is already popular, collaborate with him. Clear? Immediately you will also get promoted along with him or her, whatever the case may be. From this, the moral of the story is very simple. If you are less popular, tie up with a popular person such that you will also become popular along with him or her. Same logic stock markets also will use. My company is less popular in the public, but if issue house say to the public to buy the shares, public will blindly buy. Then take the help of issue house. What's wrong? See here, let me explain. Company will issue prospectus to the issue house. Issue house is an expert investment banker. Expert investment banker. It's not normal banker, investment banker. Investment banker means if public offers a mergers, amalgamation, they only will take care in India. Yeah. There are around 70, 80 companies are there in India who are working as investment bankers. International companies like Invesco, Franklin Templeton, JP Morgan and Chase. Okay. National level companies like SBI Cap Securities, BofA Securities, Kotak Securities, SBI Cap Securities, Axis Capital, HDFC Capital Limited. All these are various examples of issue houses who are investment bankers in India. I'm talking to you, everyone. So, those issue houses are very popular. People will believe their words also. Therefore, these companies will go to issue house. Okay, they will give you like this. Sir, take my prospectus. Read this prospectus. Listening, read the. I am issue house. Your company. Okay, you gave me this. You said, sir, this is my prospectus, sir. Please read my prospectus. Understand the culture of my company. Understand my balance sheet, P&L, my performance. If you really like me in terms of finances, then only promote me to the public. Listening. Now, I am the issue house. I will read the prospectus now. I read the prospectus. Okay. I read the entire prospectus. I felt that this is very good. Listening, everyone. Okay. I felt that this is very good. This is not a prospectus, sir. Okay. This is not prospectus. It is income tax case laws. Okay. TA next page income tax is enough. For that I compiled 700 case laws. So these are all case laws book. So summary of all the case laws. So the point is, and if I start na fire, so there should be fire na, it should not be normal. So therefore, for that purposes. Then okay, come back. So the point is, company is there. Company issued prospectus to issue house. Issue house read the prospectus. Okay. After reading the entire prospectus, issue house said, Pakka, you are a genuine company. I will promote you to the public. But what for me? If I am a very nice person, my car will not run without petrol. Okay. I should also fill my tank. So therefore, I will promote you. But what is for me? Then company will tell to issue house. Issue house is sure do one thing. I will give you prospectus. You read my prospectus. Understand my company. Believing in me, promote my company to the public. Sell the shares to them. Money will come na. That's called as a whole consideration. I will not take the whole consideration. Deduct your commission. Pay me the net consideration. And this entire process should be completed in 6 months' time. Hey, everyone. Understood? So this entire process should be completed in 6 months' time. If that be the case, let's move on. See the diagram flow. Company issued prospectus to the issue house. Issue house will not issue prospectus, will issue shares to the public. Will issue shares to the public. So from where it got shares? Along with the prospectus, if issue house give a tick mark to the prospectus, shares also will be given by the company. So company has done two things with issue house. It issued prospectus, it allotted shares. It allotted shares. To whom? Issue house. Issue house took the shares. Okay. Then the issue house will sell it to the public. Whenever shares are to be sold to the public, issue house is issuing the securities, selling the shares. It is issuing shares, selling the shares, selling the shares which are already issued. So again offer for sale will come. Yeah. Again what will come? Offer for sale will come. Okay. Now answer my question clearly. Now public subscribe to the shares. Public will pay consideration to issue house. Issue house will deduct some commission and pay net consideration to the company. This all procedure should get completed within a span of 6 months from the date of allotment. 6 months from the date of allotment. Then tell me, this will be called as prospectus or deemed prospectus. Everyone, this will be called as a deemed prospectus. Like this, you should not think this is prospectus. This is not deemed prospectus. This offer for sale is given. This will be deemed as a prospectus. Understood the point clearly or not? That's it. This is the end of section number 25. Everyone, answer, yeah, everyone understood the concept clearly. So 25 wanted to tell, if a company allot the shares, listen, if a company allot the shares to another person with a view that all or any of the securities will be offered for sale to the public, any document by which the offer for sale is made by that issue house will be deemed as a prospectus, and all the rules of law applicable to the prospectus equally apply also to the deemed prospectus emphasized in this section. How to prove that this is a deemed prospectus? Net consideration will not be received, or the entire procedure will be completed within a period of 6 months. So are you with me, everyone? Read. Let me make it full screen. Read it. Is the full screen visible to you, everyone? Okay. Take a minute time, read it properly. First day I have written one thing. Issue house giving to public at large is deemed as a prospectus. Company giving is not a prospectus. Company will really give a prospectus. Whatever you are seeing on the screen now, these are the things you need to write in exam for 4 to 5 marks. Completed. Shall we go to the next one? I gave you 3 minutes time for you to read. Everyone, shall we go to the next one? Next concept. So we have now completed 23, 24, 25, 28. Now we are going to complete 27. 27. Let us see what is this concept. See here. whenever prospectus is issued, you will issue prospectus by making some promises inside. What sort of promises? How you will use the amount received on public offer, for what purposes you are going to use, you will clearly mention in the prospectus. Here means the objective for which you raised the money, you will clearly mention in the prospectus. And prospectus is meant to do that, which means whenever you issue a prospectus, it's an indication to the public that the money that come inside will be utilized only for this purpose. Then you take the money. What happened in section 27? When 27 will get attracted, first it should be a public company. It went for a public offer by issue of a prospectus. In the prospectus, they said they are going to use the money received for a particular objective. Okay. But now they are changing the objects for which they are going to use it. Is it valid, not valid is a question. Answer is, it is subjective. Means what? You can't tell valid, not valid. Okay. So how to understand this? See, whose money you have taken? Public money you have taken. Ask them only directly whether they can change the objects or not. So listen, we are not changing the objects of the memorandum. We are changing the objects stated in the prospectus. Are you with me, everyone? We are not changing the we are not changing the objects in the memorandum of association. We are changing the objects stated in the prospectus. The purpose for which we issued the prospectus and the purpose for which we are actually using amount, both are not same. There is a variation, okay, which you should not do. For example, I'm telling you, there is a company which is in a CA education. Okay, CA education, it's a company. They raised the money from public. Okay, saying that they wanted to spend it on education. Okay, now they are going into pharma business. After taking the money, they're utilizing that money for pharma. Okay, why they asked? Immediately they said, we are going into pharma division to manufacture medicines for students getting headache in the class. So they are now diversified into headache tablets. So the point is very clear. What I wanted to tell is, listen carefully. Money taken by the company for one purpose, but when the utilization is coming, you are utilizing for some other purpose. Clear? You cannot do that directly. There is a procedure given in section 27. What is that procedure? See the screen. A company shall not vary the terms of a contract referred to in prospectus, okay, except with prior approval of special resolution. So, special resolution. Next, explanatory statement must be there. Details must be explained clearly. Next, amount so raised cannot be used for buying, trading, or otherwise dealing in equity shares of listed company. Means what? You can vary the object. For example, I have taken for iron and steel manufacturing. You wanted to use it for some other purpose. Use it. But in no case you can use it for trading on the stock markets. You cannot do that. Last one. Listening, everyone. First one, whose approval is required? Shareholders. Which resolution? Special resolution in a general meeting. You have to pass and take their approval and specify the details. Specify the details. What details? Where to place the details? Published in the newspaper. Which newspaper? One in English, another one in the local language. Okay, again, place it on the website of the company. Place it on the website of the company, indicating the justification for such a change. Why you are changing the object? When you took the money, you said something. Now you are saying another thing. Why you are changing the object? What is the purpose? Is there any pressing need for you to change it? Who asked you to change? Give justification. One, newspaper. Second, on the website. Listening. Now you tell me, I should obtain which approval? Special resolution. You tell me, special resolution means 100% approval. Special resolution means 100% approval. No, need not be 100. Okay. If one person vote in against, 3% should vote in favor. Correct or not? Ante in every 4, 3 should vote in favor. Ante 3/4 approval is required. 75%. Correct or not? And how many can disapprove? 70, 100 plus 75 said yes. Means how many are disapproving? 25 are disapproving. Respect the 25 also. Just because of the reason that they said their voice is not representing. Don't take them for granted. That's why what it said. See, the dissenting shareholders and a balance 25 shall be given an exit offer. Exit offer means what? See, 100 people are there. 75 people said, sir, we love that company. That company do iron and steel. We love iron and steel business. That company do IT business. We love IT business. That company do some nonsense. We love that nonsense. And if we don't love what they do, okay, honestly, we love that company. That's it. Whatever they do, we are supporting it. 75 by people. Remaining 25 who disapprove now, do you know what they will tell? We came not for company. We came for iron and steel business. When you change the object now, why we need you? We will go to another company. Therefore, those people are called as a dissenting shareholder. Give them exit offer. Exit offer means what? Those people don't want to continue in this company anymore because objects are changed. Give them cash for the shares they purchase. Send them out of the company. That's called as exit offer. Everybody answer, understood the point clearly or not? Okay. You have to give justification by advertisement in newspaper. Na? That should be in PAS1 form. Here, that's it. These are all the main concepts in section number 27. Up to here, everyone understood the point clearly? Everyone understood? This is all governed by section number 27. So 23, 24, 25, 27, 28. 23, 24, 25, 27, 28. These are the things we completed till now. And everyone in the class, please answer. Did you all understand the concept up to here? Now we are going into the second segment of discussion. These areas are yes, all these areas. Whatever you are seeing on the screen now. 34 to 42. Mark my words. We will meet on exam day again. One question will come from this. Again, I am repeating without my mistake. 34 to 42, one question will come. Okay. 31, 32, 33, 34, 31, 32, 33, one question will come. So, 5 kinds of prospectus are there. From that, one question will come. From this, one question will come. Totally, prospectus will come for 9 marks. Shall we begin? 2 minutes time I will give. Because I will tell you the reason. Listen. Time given for this is ante 34 to 42 kada. 34, 35, 36, 37, 38. 5 section set. This 5 section set I am giving 30 minutes time. Not more than that. So what I will do is, before even starting with the session, my discussion, I will give 2 to 3 minutes time for you. Whatever book you are preparing, open that. Just revise that very fast. After that, you listen, clarity will be more. Okay? 2 to 3 minutes time. Just revise what you read before. Most of the people I am seeing here are from our direct classroom students only. So already we read the Bare Act. We completed it. The work you have to do is go through that fastly. 34, 35, 36, 37, 38. Fastly you go through. Once you complete with some 10% knowledge, balance 90 I will cover now. Are you listening to me, everyone? And moreover, other than this, anyone listening to the lecture live or anyone listening to the lecture recorded, whatever the case may be, please first read 34 to 38 normally, whatever the document you are reading. Then we will be going with a revision. Because compulsory this time, I am expecting one question to come from this area. So listen, I hope everyone might have already got through the concepts what I asked you to read. 34, 35, 36, 37, 38. Okay. Everyone, have you completed? Now, let's start. 2 minutes time we are going to spend on each section and try to complete it as soon as possible. Let me first explain you the logic of all the sections. Okay. First I will tell about 33, 34, 35. Okay. 33, 34, 35, 36, 37. These sections I will first discuss. 30, 34, 35, 36, 37. 4 sections. Okay. First one, 34. Whenever prospectus contains any misstatements, misstatement means false statements intentionally. Whenever any kind of false information is going inside the prospectus, public believe in those false statement and purchase the shares. Okay. Therefore, if prospectus contains any material misstatements or omission of a true statement, both of them are equally wrong, equally fraudulent. Means what? Giving wrong information is mistake. Not telling right information is also a mistake. So both are equally dangerous. Therefore, what the law has said to us, law says like this. See, 34 will be talking about criminal liability. 35 will be talking about civil liability. What do you make criminal liability? For the wrong done, punishment should be given. That is criminal liability. That will be fine, imprisonments. Civil liability means because of your mistake, some innocent person is suffering. You should compensate that innocent person from his suffering. That concept is called as civil liability. Okay. Criminal liability means fine and imprisonment. Civil liability means compensation to the victimized person who was a victim because of your mistake. To him, you should pay compensation. That's called as a civil liability. I hope every one of you are here in the class. Done. Let's continue. If prospectus includes any statement which is untrue, which is misleading, then who is liable? Every person who authorize means sign the issue of prospectus shall be liable under 447. Okay, shall be liable under 447. Sir, to some persons that liability will not get attracted. Who is that fellow? Lucky person to whom this concept doesn't apply, and a punishment 447 punishment do not apply to him. Do you know whom? Such a statement was immaterial. I made a wrong statement, but because of my wrong statement, his judgment will not go wrong. Example. Example. Name of director. We have to write in prospectus. We have to write in prospectus. Let's say I am the director. My name I have to write like this. Example. Company has written my name like this because so many people use it to write like this. Instead of KOU, they have written KAU. Now you tell me, there's a misstatement or no misstatement? There is a misstatement. In reality, in my Aadhaar card, passport, visa, US visa, wherever you see, my name will be KOUSHIK, not KAU. Okay, they mentioned KAU. There is a mistake. But you tell me, because of mentioning nouns, especially not even verbs, adjectives, pronouns, etc. Nouns K, will you really be very specific about my spelling? Now tell me, misstatement is there or not? If that be the case, yes, misstatement is there. But that misstatement is a material or immaterial? Immaterial. Then 447 liability will not get attracted, though there is a misstatement, because that misstatement impact is immaterial. Everyone understood? Next, second one. Second one. That he had, okay, reasonable ground to believe. Reasonable ground to believe that the statement was true or inclusion or omission was necessary. Means what? Sir, I didn't understand this. Very simple answer. Listen. In audit syllabus, already in one of the previous class I told, again I am repeating, using work of an expert. Have you gone through that? Civil engineer using the work of an expert. Auditor cannot do civil engineering valuation. So what he will do, he will call one civil engineer who is an expert. He will ask him, please value this building and tell. He valued and given. Hey, listening. Now you please tell me the answer. Civil engineer valued the land and building and he said 2 crore. Auditor in the balance sheet has taken the 2 crore value and he signed on the audit report. Listening. But really, value is only 1 crore. Okay. Mistake is with the auditor, mistake is with the expert. Therefore, what auditor will do? I have reasonable ground to believe that. Okay, auditor has a reasonable ground to believe that the statement made by civil engineer was true. That's it. I believed on that and I signed. Just because of the reason that I signed, don't put auditors in jail because they believed in the expert work. Okay, so two situations la you can escape 447 and come out. What are the two situations? You should prove that the misstatement or omission is immaterial, or you should prove that you believe that, or you have a reasonable ground to believe that the statement was true or omission was necessary. This is all dealt by section number 34. Are you all understanding the point clearly or not? Next, civil liability. Okay, 1 second. Okay, see here, 34 completed. Now we are coming into 35. What is 35? 35 is talking about civil liability. 35 is talking about a civil liability. Okay, let us see. See here, 35 will be talking about civil liability. Let us first understand applicability. Where a person has subscribed for the securities. What do you mean by subscribe? You should not purchase from stock market. Directly from the company. When company is going for application allotment, at that time you should buy. Okay, that's called as subscription. Okay, so section 35 will get protection only if the person complaining in the court must purchase shares from the company, not from stock market. For example, company went for public offer. I purchased the share. I transferred to you. You purchase the shares. You purchased by reading prospectus. You cannot complain because you did not subscribe from company. You purchased it from Kaushik Mukesh. Understood the point or not? So to get 35 getting attracted, first condition is what? It should be a subscription concept. So where a person has subscribed for the securities of a company, acting on any statement included or omitted in the prospectus. Acting on means what? Believing the. Okay. So I am an outsider. I read the prospectus, believed that it is true. Acting on that belief, I subscribe for the securities. And those statements are misleading. Because of that wrong statement, omission of true statement, I have sustained a loss or I incurred a damage as a consequence. In such case, who is liable? See the screen. Company. Every person who is a director at the time of issue of prospectus. Some people will tell, write my name as a director in your records. Those who authorizes to be himself as a director. Next, some directors will tell, write my name, I will agree to become director. Those directors, so simply directors, proposed directors, both kind of directors will become liable. Promoter liable. Anyone who signed on the prospectus liable. Experts are liable. So above person shall be liable to pay compensation to every person who sustained loss or damage. So 34 civil liability intention is to punish you. 447. 35 is to pay compensation, civil liability. Listening everyone. Final touch. Who will not be liable? Like this. Here we read the immaterial. He has a reasonable ground to believe. We read or not. Like that. Here also, who can escape civil liability? Having consent to become director. withdraw the consent and prospectus was issued without consent. Means what? See, today I agreed to become director. Today I agreed to become director. Okay. 1 month after, prospectus was issued. Prospectus was issued. Okay. Prospectus was issued 1 month after. Prospectus is sent for registration 15 days after. In between, I have withdrawn my consent to become director. Means originally I consented to become director, but I withdrawn my consent. I said namaste to your company. I don't want to become director. Without my consent, you issued the prospectus with my name. I will not be responsible. Okay. Next, second one. Prospectus issued without knowledge or consent, on becoming aware, gave a reasonable public notice. One of the directors in Singapore, he is on a trip. Okay. India company is there. It issued prospectus. This fellow is in trip. He don't know what is happening in India. Clear? His name is also there in the prospectus as a director. If mistakes are there, he will also become liable or not. Immediately after becoming aware about prospectus, he gave a public notice in newspaper that I am in Singapore. I don't know what is happening in India. So I am not responsible for that prospectus. Like that, if you give a public notice, then you will not become liable, even though there are misstatements. Understood? Next. Same third point is same. Expert has given a report. On the basis of that expert report, I have a reasonable ground to believe that expert is competent and he has given the consent and not withdrawn the consent. See, there is an, listen to my points clearly. There is an expert. Expert has given an expert report and he has given his consent for that report. He did not withdraw the report consent. Means Kaushik Mukesh has given a report and he is saying report is correct. Kaushik Mukesh did not take back his consent to sign on the report. Means what public will believe? Expert is confident. On the basis of that expert document, auditor has commented something. For that, you should not make auditor liable. If proven that prospectus is issued with the intent to defraud, okay, then every person under subsection 1 shall be personally responsible. This is called as joint and several liability. Which liability? Joint and several liability of all the persons. Okay. I am putting this document before you. 1 minute time for each section. So totally 2 minutes. Complete 34, 35. Very important for exam. 34 to 38. One question pakka will come in this exam. Please read 34 and 35. Can I go to the next one? 34, 35 completed. Can I go to the next one? Okay. Next. This is only summary for you to understand. 447 punishment for fraud. I kept in the form of a table. Okay. You can read it later because punishments, normally I don't take care about the punishment because punishments is something which student has to remember. It's not about I going to teach. I will tell 5 years imprisonment, 7 years imprisonment. What you will get? Okay. You have to remember the penalties and punishments. Okay. It's not my work. So, next one. 36, 37. Let us complete these two. 36, 37. Okay. See here. Punishment for fraudulently inducing a person to invest money. Sir, what is this? If any person force any other person to do any of these three things, okay, then he will be liable under section 447 again. Okay. What are the three things that you should not do? See, first one. Any person who knowingly or recklessly, reckless means negligently, knowingly means intentionally, any person who knowingly or recklessly makes any statement, promise or forecast, okay, makes any statement or a promise that it will definitely happen or forecast like this, it can happen in future. Okay. You are recklessly making that statement without knowing about the market. Second, or knowingly recklessly making a statement, that statement is a false, okay, or you deliberately conceals a material fact to induce another person. Induce means what? To force another person to enter into any agreement, because of entering into that agreement, that other innocent person life is gone, then you will also be kept in jail under section 447. Sir, I didn't understand. I will tell in a understandable language. Listen carefully. This is very, 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 very popular in India. Fraudsters are there in India, na? They do this way. See, there will be Mr. A. Mr. A is a portfolio broker. Okay, he will be having knowledge on stock market to some extent. Okay, to some extent. 2023-24 time, SEBI passed one regulation. At that time, chairman of SEBI, Sri Madhavi Puri Bash, she was the chairperson of SEBI in the year 23-24 financial year. She brought one very good, fantastic regulation on stock markets. Do you know what is the regulation they brought? Listen. The regulation says like this. If any person, mark my words, if any person tries to give any kind of canvassing, counseling, advices on stock markets, on social media, other than a chartered accountant or any person who had a professional degree with NISM or CFA, he will be liable for punishments with the SEBI. Means what? Simply to tell. That's why if you observe 24 year and the last year, before if you see Instagram, if you follow, every 10 reels, one reel used to be on stock market at that time. Some nonsense fellow will come. Buy this stock, buy that stock. If you buy this, you will become Mukesh Ambani. Like that, they used to tell, na, all are plugged by section 36 now. Are you understanding the point or not? Any nonsense idiot standing on social media and confusing public about their investment with the slipper, SEBI will hit him first. Because, sir, understand the seriousness of the issue in India. People in India, 70% of the public are middle class families. Okay. Whenever we say middle class family, try to understand how the emotions are. They want money. Because from the very first moment, the moment they are born, they were not born in money. Okay. Their parents are hard earning. Listening or not, from morning till night, they will be working. So seeing them, these people will grow. When money is the thing, they will immediately get attracted to that money, taking their weakness as an advantage. If these idiots are shouting like barking like dogs on social media relating to the stock market, SEBI became very serious. You know what they said? 36 will be invoked on all the social media barking dogs on stock market without a proper certification. We respect people who have certificate to speak on the issue. Did you understand what I said? There is a person, NISM certified, you have a right to speak. There is a chartered accountant, you have a right to speak. There is a professional on stock market, you have every right to speak about the market. Just because of social media platform influence or just because of getting followers, you should not speak nonsense, na? Because believing in you, thousands of people might follow this wrong strategy. Listening? That's why previously, if you see on YouTube channels or Instagram, I became millionaire in one day thumbnail. If you go inside futures and options, he will be putting money. Futures and options, like government directly gave research paper. Do you know what happened? 91% of the investors in futures and options are seeing miserable losses in India. Means what? It's a gambling type, yeah. Futures and options is like a gambling bet. You should not enter into that futures market. You ask me, I will tell. I lost money, I kept money. I earned money, I lost money. Both happened. So, futures and options like kept money. If I get 100 rupee, na, I lose 30, 40 rupees also on the same side. But because of my knowledge, because of certifications that we make, I may have some knowledge as to what to do further. But a normal person, how he will know? He will fall into the trap. Therefore, she became very serious when she was the chairman of SEBI. Hats off to that lady. She took a bold decision. Whatever the social media platform the people will say about me, nonsense. If someone tries to do any kind of inducement and forcing the person to invest money recklessly, if you make any statement, nonsense promises and forecast, purchase the shares of NCL, purchase the shares of TCS. After 1 year, you will become king without a crown. Don't do all those nonsense. How do you know what will be the price of TCS after 1 year? Did you understand the point or not? How do you know? Chairman of TCS don't know what will be the next share price. How do you know? So don't try to induce the people knowingly, recklessly make any statement which is deceptive, cheating, and conceals material fact and inducing another person to enter into any agreement. Do you know what is a dangerous agreement Indian public are entering into, which led to some suicides also in India? Banking transaction. Do you know what these idiots will do? These are non-certified nonsense idiots. These people will force. For example, one innocent fellow is there, middle class person, employee, earning somewhere around 50,000, 60,000 per month. 50,000, 60,000 per month is not a very good salary in India today. 50,000 he is earning. What he will do? A person went to him and said, sir, you give me 50,000, every month you give me 10,000 rupees for next 1 year. Your 1 lakh will become 3 lakhs after 1 year, he will tell. What this poor fellow will think? If I put it in the FD, 8% interest, 10,000 will become only 10,800. If I give to him 10,000 is becoming 12,000. Extra 1,200 or 1,300 is coming. Like that they will feel and they will give money. Are you listening? Some more idiots made one step forward and they have done like this. Let us say I am that villain. I will take the position of that villain and I will explain you. You are the innocent fellow. I am that nonsense fellow. Let us understand this way. I will come to you and say, see the TCS. Last year, 3,800 per share. I told to 50 people to buy. They did not. Now today it is 4,300 rupees. Today also I will tell. No one will buy. After 1 year it will become 5,000. These people also will get regret. I don't want you to be in that position. So I'm giving an advice. Buy the shares of TCS at 4,300. Buy 100 shares. Buy 1,000 shares. He will tell, Arey, my monthly salary 60,000 muttal. How can I buy 4,300 into 100? Mind unda poyinda. Mula illana. Nai. Like that he will tell. Are you understanding the point or not? So, my salary is 60,000 means 4,300 into 100. 4,300 into 100 will be 4,30,000. My monthly salary is 60,000. How can I buy? Now I will tell this way. Okay. No. Monthly salary you need not invest. I have one bank. Okay. He's the manager of that bank. Come here. This fellow also will come. Okay. Chota Nai. He will also come. Now he will come. This fellow also will come. Now he will tell, see, my friend, bank manager, living legend. Okay. What he will do? He will give you loan, stock loans. What do you mean stock loan? You buy the shares, na? For that he will give the loan to you. 12%, meager interest rate. 12%. You invest, you will get 25% return. 25 or 12%, even if you pay to him, 12% is still surplus to you. Financial leverage, financial management. So he will tell, borrow at a lesser rate, invest at a higher rate, get the financial leverage. Like this, he will tell to that poor fellow. Now you are the one. Now you will believe. Oh, so my monthly salary I need not. So I will take loan of 4 lakh 30 from your friend, from the banker. 4 lakh 30 I will take. 12% I will pay to him. Remaining 12% is my profit. So super, yeah. He will invest. The moment he start investing, stock price will come down like this. Okay. 4 lakh 30,000 share price will become, for 4,300 will become 4,200. But loan taken on 4 lakh 30,000, na, on that he will ask 12% interest. Hey, are you listening? Here I am. Here you being an innocent fellow is facing two problems. Number one, principal 4 lakh 30 you have to pay. Listening? You have to pay after 1 year. After 1 year, share price came to 4,100. You sell all the shares, you will get 4 lakh 10,000. You have to pay 4 lakh 30,000 principal. 20,000 loss to you. Second, interest will be paid on that 4 lakh 30,000. Both these, normal middle class fellow, how he can afford? He will not pay. Eventually, he will go into depression. His family will suffer a miserable loss. Understanding all these nonsense in India, she brought that rule. Clap for her, everyone. So, such a great rule was brought by her in the year 23-24 financial year. Okay. She was irritated with these people shouting on social media platform during the COVID time. Listening or not? So, this is what happened in India. Why I am telling this is, at least this way you will remember 36 section importance. Yeah. So that's why, see here. Any person who does any of these four and inducing innocent fellow like you to enter into agreement. Which agreement? Agreement to subscribe, agreement to acquire, agreement to dispose, sell, agreement to underwrite securities. Or you said, buy the options and futures. Options and futures ki one concept is there. You will not buy the share, you will not sell the share. Only profits will be booked. You will not buy the share. You will not sell the share. What will be booked? Profits only will be booked. So therefore, securing any profit to any of the parties from such securities, or third one, bank loans, obtaining credit facilities from any bank, then they will be liable under section number 447. Everyone understood the intensity of section number 36 or not? Next. 37. Action by affected persons means a suit may be filed. Suit means a case, or by any other action can be taken under 34, criminal 35, civil 36, punishment for fraudulently inducing, by any person or group of persons or association of persons affected by misleading statement. Simply to tell, court law, who should make a complaint? Either one person can make, or group can make, or an association of investors also can make. Anyone can file a complaint in the court. That's what said in section number 37. Everybody answer. Understood all the sections? 34, 35, 36, 37. Understood or not? Pakka, everyone, can I believe you? Done. We have now completed the most important aspects in that. Remaining all are only procedural section. Now I will give you time for you to read 39, 40. 39 and 40. 2 minutes time for you to read, 10 minutes time for me to explain and complete. The next sections we are going to start is section number 39 and section number 40. Okay. 39 and 40. Once 39 and 40 are completed, I will be next dealing with 3 areas: red herring prospectus, shelf prospectus, information memorandum. That's it. This is the main concepts that we need to discuss. Shall we? Let's start. See here, section number 40. 39, sorry, I'm very sorry, 39. Allotment of securities. A company can allot shares to the public only when amount stated in the prospectus as a minimum amount has been subscribed. Means application money taken. Next stage, allotment. You cannot do the allotment unless minimum subscription amount is received in the form of application money. How much is the minimum subscription? 90% of the total subscription. How much? 90% of the total subscription. They need not pay. They should at least subscribe. Sir, what do you mean, sir? See, company went for a public offer. They made 1 lakh shares available for subscription. Okay. Public should at least subscribe 90,000 shares. Understood, everyone? Okay. 90,000 shares ki amount they don't pay immediately. Amount will be paid in 5 installments. Application, allotment, first call, second call, final call. We are not talking about this. We are talking about this. So, in 1 lakh shares, at least 90,000 shares they should subscribe first, and 90%. So, whatever the minimum amount you stated in the prospectus must be first fully must be subscribed. Next, application money collected, that should be collected only by check or any other instrument, not in cash. Okay, 2 conditions. When you can go for allotment, 2 conditions must be satisfied. Amount stated in the prospectus as a minimum subscription has been subscribed, and sum payable on application money must be paid by a check or any other instrument, not by cash. Next, application money shall not be less than, okay, for example, issue price is 10 rupees. Application money must be at least 50 paisa, 5%, okay, of the nominal amount of securities. Okay, na? So application money shall not be less than 5% of the nominal amount. Next, if the minimum amount stated has not been subscribed and application money is not received within 30 days or any period specified by SEBI, period specified by SEBI is 60 days. Ante listed companies ki 60 days, unlisted companies ki 30 days. Like that you have to remember. Everybody answer understood? Listed companies ki 60 days, unlisted company allotment ki 30 days. Are you with me, everyone? Okay. Now, so whenever application money is accepted, okay, allotment must be made. If allotment is not made, refund the entire money within next 15 days. If you do not refund the money within next 15 days, you have to pay interest at the rate of 15%. Everyone understood the concept clearly? Yeah. See, when company having share capital makes an allotment, file with ROC a return of allotment in form number PAS3. Default, company and the officers in default. OID, it's not OLD. OID. OID means officers in default. Liable for 1000 rupee fine per day or 1 lakh, whichever is lower for each default. Next, return of allotment. Return of allotment shall be filed in PAS3 within 30 days of allotment. Attach list of the allottees, means whoever is allotted with the securities, their name, address, occupation, and number of securities. Okay, so these are some basic details that you need to read, not for exam, just for your knowledge sake. Main concept. Let's revise everything. When a company can go for allotment, 2 conditions must be satisfied. Amount stated in the prospectus as a minimum subscription must be subscribed by the company. Number 2, amount of application money must be received any mode other than cash, means check as an instrument you should receive. Over. Next, whenever application money you are taking, it should be not less than 5% of the nominal value. Next one, if the amount is stated if the amount of minimum subscription is there, that should be received within a particular period of 30 days or 60 days. Unlisted companies ki 30 days, listed companies ki 60 days. Within this 60 days time, if you could not allot the securities, you have to refund back entire amount. Okay, refund within how many days? Next to 15 days. If you do not refund, what will happen? Directors who are officers in default shall be jointly liable to pay 15% interest per annum. Everybody answer understood or not? Whenever allotment is made, within 30 days of allotment, file with ROC, form PAS3 called as a return on allotment. If you do not file, punishment will be there, minimum 1000 per day, which will go up to maximum 1 lakh. Everybody understood the point clearly? This is all said in section number 39. Next issue. Section number 40. Section number 40. Securities to be dealt within stock exchange means once you are a listed company, purchase and sale of your security should not be between two people. It should be through the stock exchange only. See here. Whenever a company, unlisted company, wanted to go for public offer and become listed, even before making the public offer, first it should enter into agreement with either one or more stock exchanges in India. Two popular stock exchanges, NSE, BSE. For example, my company wanted to go for listing. Okay, directly you cannot go and issue shares to public. First, you need to enter into agreement with any of these two stock exchange, either one or both. So that's why before public offer, company to make an application to one or more recognized stock exchanges and obtain their permission to be dealt in the RSC. Okay, next. Where prospectus states application under subsection 1 has been made, state the name of RSC. Means whenever you are issuing the prospectus, in that prospectus you should clearly mention after going for listing, once the public issue is successful, in which stock exchange we are going to sell your shares, you have to write that in the prospectus. From this, what is the moral of the story? Listing agreement should be entered with the stock exchanges even before issue of the prospectus. Therefore, for example, I will first go to NSE and ask, sir, these are my company details. Will you accept my company to list my securities on your exchange? If public issue is successful, they said yes. I will write the name of National Stock Exchange in the prospectus and give to the public. Are you listening, everyone? Next. Application money shall be kept in a separate bank, in a scheduled bank, not to be utilized for any purpose other than application money can be utilized only for two purposes. Number one, adjust to the allotment money. Number two, refund. Adjust to the allotment. Number two, refund. Understood? Next. Main contents I will discuss. So commission can be paid. Underwriting commission. Okay. How much underwriting commission I can pay? In case of shares, 5% of the issue price, issue value, 100 crore public offer, 5%, 5 crore, rate authorized by the articles. Articles have authorized 4%. You have given 5. 5 or 4 are whichever is lower. For example, articles prescribe 6. 5 6, whichever is lower, 5 will apply. Running. In case of shares, underwriting commission can be 5% of the value of issue. Okay, in case of debentures, 2.5% are rate authorized by AOA, whichever is lower. Everyone understood the concept clearly? That's it. These are all the main concepts we need to deal in section number 40. So we completed the most important set. 34, 35, 36, 37, 38, 38 anyway not there here, 39, 40. These all sections we have covered. After thorough coverage of all these sections, everyone tell me, understood the points clearly or not? Last set of discussion in the prospectus chapter from the exams point of view. 3 concepts. I will give 3 minutes time. Red herring, shelf, information memorandum. Start. Red herring, shelf, information memorandum. Please read, everyone. Read 31, 32. 30 and 33 are small sections. You can't even expect them to come in exam. Leave them. Main contents. In the intense batch, the main purpose is the main core areas of this chapter we are going to cover. Let's not waste time in unnecessary areas. Completed, everyone? 31 and 32. Shelf and red herring. Okay. So see here. Let me explain the purpose of red herring prospectus and shelf. Concepts are very simple. Max 5 minutes each will complete. Red herring prospectus is a prospectus which is issued 3 days prior to the issue of prospectus. Simply to tell, what is the purpose of a red herring prospectus? If a company is going for public offer for the first time, they don't know two things. Number one, how much price to fix. Number two, how many shares to issue. Therefore, what they will do, they will obtain the demand availability from the public itself. Okay. Online, they will open one blog called as online on the Zerodha, Upstocks. These kind of apps are there now. On those apps, they will open their public offer document and they will ask a concept called as a book building process. Which process? Book building process. What is this book building process? For example, Kaushik Mukesh is there. He will go to Zerodha website. Once I enter into that, there one mark will be there. New IPOs. I will click. Immediately X Limited example is there. I clicked on X Limited. There they will write RHP, red herring prospectus. I will click on that. Download. I will read the RHP of this company. Profit loss account, important 5-6 pages I will read. I was impressed. Very good. But I wanted to know what is the caliber of this company, how much price they are fixing. Then I will go to the website. Again, Zerodha website, click on the issue price. They will give me a price band they will give. 120 to 130 they give. What do you mean by 120 to 130? Means within that price band, price range of 120 and 130, investor can apply for a price. Kaushik Mukesh will go 125. I feel that this is the best price for this company. How many shares? 1000 shares. 125 into 1000, 1,25,000 rupees. First, you have to pay from your bank account. Then your detail will reach the company. Okay. From this, what you have to understand? Red herring prospectus is a prospectus which contains all particulars except two particulars. Number one, particulars of price, particulars of quantum of securities. Particulars of price, particulars of quantum of securities. So, demand discovery, price discovery will be done using a concept called as a red herring prospectus. So, for example, this is red herring prospectus. Okay, see here. Let us say, for example, this is what? Red herring prospectus. This contain all the details of prospectus, but price place la block. There will be a blank. Number of shares placed, there will be a blank. Remaining all the details will be there. When I will fill that, once I receive demand from the public, I will average it out. I will fix a number of shares finally. I will fix a final price also. Okay. Kaushik Mukesh clicked on 125. Real price is fixed at 126. Extra 1 rupee I have to pay on each share. Kaushik Mukesh clicked on 125. Final price is fixed at 120 only. Now I will get a refund of 5 on each share. Did you understand my point or not? I'm talking to everyone in the class. So this is the idea behind red herring prospectus. Okay. See. Prospectus which do not contain complete particulars of quantum and a number of shares, price of securities. Done. Next. Company proposing to make an offer of securities may issue RHP prior to the issue of prospectus. Means what? There are two prospectus now. Red herring, final. Before issuing final, first give red herring. Demand and number of shares, price will come. Put these in the final prospectus. RHP should be filed with the ROC 3 days prior to the opening of subscription list. Means before accepting the money, at least 3 days before, RHP should be made available on the websites. Next, 3 days. Important for MCQ. RHP will have same obligation. Same obligation. Everything will be same like a prospectus. Okay. RHP and final prospectus will be same? Huh? No. There are some differences. Price will not be there in RHP. Will be there in final. Number of shares will not be there in RHP. Will be there in final. So whatever variations are there between RHP and final must be highlighted as variation. Did you understand, everyone? Next, last one. Upon closing of offer, means offer is closed 5-6 days after. The prospectus means final prospectus should state total capital raised. Now again, particular should not be incomplete. Now you understood now how much shares has taken. Total capital, closing price. Why not price band? Price band is in RHP. Final prospectus will contain the closing price. Understood the point clearly? So, final prospectus will contain total capital and closing price and other details not included in RHP. Understood the RHP section clearly, everyone? Next, shelf. I will explain shelf prospectus and close. Listen carefully to the shelf prospectus concept. See here, please. Some companies will go for multiple public offers in a particular year. Will go for multiple public offers in a year. At the time, it is not viable for them to issue prospectus every time they go for a public offer. Therefore, shelf prospectus concept came. Shelf prospectus is a prospectus where it will be issued only once at the time of first issue of securities. At the time of first issue of securities, one time I will issue. From there, 1 year, for example, today, 9th April. 9th April, I made my first offer. From 9th April to the next year, 8th April end, this prospectus will be sufficient. So you can make any number of public offers on the basis of this shelf prospectus. That concept is called as a shelf prospectus. Shelf prospectus life is 1 year, not one financial year, not one calendar year. 1 year from the date of opening of first offer of securities. Listening or not, everyone? Next. See, today is the 9th of April. 9th of April, I issued a prospectus, shelf prospectus. Validity period 1 year. In the month of June, some important events happened. Okay, what events? Some assets are subjected to charge. Okay, some assets are subjected to charge. Second one, company lost a legal case. 100 crore penalty is paid by company. Second major event. Third one, MD resigned from the company. Third important event. These three events are there in shelf prospectus or not there in shelf prospectus are not there. Why it is not there? Because shelf prospectus is given before these events occurrence. Correct or not? So these major events which have occurred after the issue of shelf prospectus are not reflected in the shelf. Therefore, information memorandum concept came. Information memorandum is a document containing important events that occurred after the shelf prospectus before the expiry of that 1 year. Did you understand the entire story of shelf prospectus or not? Now, let's read and complete. Okay. Meaning, shelf prospectus means a prospectus in respect of which securities or classes of securities included are issued for subscription in one or more issues over certain period without issue of further prospectus. So one or more issues can be made with one prospectus only. Next, provision. So any class of companies can issue shelf prospectus with ROC when at the time of first offer of securities. Okay, validity period not exceeding 1 year. From when it will start? Date of opening of first offer. For subsequent offer of securities, no further prospectus is required. You find all the points what I said in the notes or not? Next. Next one. Information memorandum, PAS2. Within 1 month prior to the subsequent offer. For example, we wanted to make 6 public offers in a year. Okay. First public offer over. After first public offer, before second public offer, new charges created. Financial position changes. Any important changes happen, inform in the form of information memorandum. Understand the point or not? Okay. These are some important points. Okay. So, for example, public offer 1 completed. Okay. Public offer 2 is getting started. 2 is getting started. 2 is made. Public paid money. Immediately new charges created. MD resigned. These things happened. You have to give exit offer to them. If they withdraw, refund their payment within 15 days. That means if any shareholder who saw the shelf prospectus and invested, later changes happened, which are dangerous changes, you should refund their money within the next 15 days. This is the end of the concept called as shelf prospectus. These are all some main concepts which you need to read for the exam, because private placement has already come in the last examination and before exam. Chances of coming again in this exam is very less. Clear, everyone? So in the chart material, just to give one reading and leave if you want, but actually no need of that also. If you want, just give one reading on private placement and leave. Whatever is very important for the examinations, for this examination, I covered all those things in this revision session. Everyone in the class understood the prospectus chapter clearly? Everyone in the class? Okay, then. Thank you very much. Next session we'll continue with another one more chapter and take another 5 to 8 marks out of it. So that's such that in this also we can grab another 40 marks of the revision portion. Clear? So thank you very much. All the very best. Prepare well.